Greetings and welcome to Courts This Week on LiveLaw. I'm Taniya Pandey and I'm here with our weekly update from courts across India. Let's go over judgments of the Supreme Court first. The Supreme Court has observed that Section 17 A of the Prevention of Corruption Act 1988 is not retrospective in nature. Section 17A of the Act came into force on 26 July 2018 and provides that there cannot be any inquiry or investigation without prior approval of the appropriate authority. The bench of Justice Indira Banerjee and Justice J.K. Maheshwari, while allowing the appeals, observed that it could not possibly have been the intent of the legislature that by bringing the amendment, all pending investigations up to July 2018 should be rendered infructuous. In a significant judgment, the Supreme Court on 10th February directed the Madhya Pradesh High Court to reinstate a resigned woman additional district judge who had raised sexual harassment allegations against a then-sitting judge of the Madhya Pradesh High Court. The bench of Justices L. Nageshwar Rao and B.R. Gavai held that her resignation in the circumstances of the case cannot be construed as voluntary and therefore quashed the decision of the High Court to accept her resignation. The bench had reserved the judgment on 1st February. The Supreme Court on 7th February directed that the work of demolition of the twin 40-story towers in Supertech's Emerald Court project in Noida shall commence no later than within a period of 2 weeks. In August 2021, the Supreme Court had upheld an order passed by the Allahabad High Court directing the demolition of the twin 40-story towers in the Emerald Court project of Supertech Limited in Noida for violation of building norms. While giving a last opportunity to fugitive businessman Vijay Mallya to appear, the Supreme Court of India on 10th February expressed a clear intention to go ahead with the sentence hearing in the contempt case against him and posted the matter for hearing on February 24th. Vijay Mallya was found guilty of contempt in 2017 for disobeying court's orders in not disclosing full particulars of the assets in a case between the State Bank of India and Kingfisher Airlines. The Supreme Court on 9th February issued notice on the special leave petition filed by Amazon against Delhi High Court's order staying further arbitration proceedings before the Singapore Tribunal against the Future Group till February 1st. A bench of CJI N.V. Ramana, Justice A.S. Bopanna and Justice Hima Kohli issued notice to respondents Future Retail Limited and Future Coupons Private Limited and directed for listing of the petition on 23rd February. A bench of CJI N.V. Ramana, Justice A.S. Bopanna and Justice Hima Kohli is hearing an application filed by Cal Airways seeking vacation of stay granted by the Supreme Court on Delhi High Court's order directing SpiceJet to deposit Rs 243 crore in their dispute. The top court on 10th February sought Cal Airways' response to SpiceJet's offer for full settlement of the share transfer dispute between SpiceJet and its former promoter Kalaniti Maran and his firm Cal Airways. The bench has asked the Airways to consider and revert to the proposal made by SpiceJet and decide if the offer is feasible for them by 14th February. The Supreme Court has observed that in cases where the decree passed by the trial court merges with the judgment and decree passed by the High Court, then the application for correction of decree can only be maintained before the High Court, where the decree was confirmed. The bench of Justices A.M. Khanvilkar and C.T. Ravikumar was considering an SLP assailing the Karnataka High Court's order dated 3rd June 2016. The issue for consideration was whether an application filed for correction of the decree, which has been confirmed by the High Court while deciding the appeal filed there, on merits can be corrected or altered by the trial court, keeping in mind the purport of Section 153 A of the Code of Civil Procedure. Let us now go over important judgments from the High Courts and other courts. A full bench of the Karnataka High Court, through an interim order, has restrained students from wearing any sort of religious dress, regardless of their faith, in classrooms while the court is considering the matter. The High Court is hearing petitions filed by few Muslim students challenging the hijab ban in government colleges. The bench of Chief Justice Rituraj Avasthi, Justice Krishna S. Dikshit and Justice J.M. Khazi clarified that the order is only applicable to those institutions which have prescribed a uniform dress code. The Allahabad High Court on 10th February granted bail to Ashish Mishra, prime accused in the Lakhimpur Kheri violence incident. He is the son of Union Minister Ajay Kumar Mishra and had moved the court after his bail plea was rejected by the lower court. A case was registered against Ashish Mishra for an incident that took place on October 3, 2021, when several farmers were holding protests against the visit of Uttar Pradesh Deputy Chief Minister Keshav Prasad Maurya to Lakhimpur Kheri district, and 4 protesting farmers were killed after they were mowed down by an SUV. The Delhi High Court on 11th February reserved order on the bail plea filed by Avanta Group promoter Gautam Thapar in connection with the Yes Bank loan fraud case. Justice Manoj Kumar Ohri reserved the order after hearing senior advocate Mukul Rodgi appearing for Thapar in the matter. Thapar was arrested in August 2021 in connection to the allegations of misappropriation of funds granted by Yes Bank in the form of a loan. An ECIR was registered against Thapar and others alleging criminal breach of trust, cheating, criminal conspiracy and forgery for diversion and misappropriation of public money during the period 2017 to 2019, thereby causing losses to the tune of Rs 466.51 crores to Yes Bank. The Madras High Court has recently set aside a number of reassessment notices issued under the 1961 Income Tax Act by iterating that the Taxation Relaxation Act 2020 only extends a period of limitation and not the application of repeal provisions in light of the amended provisions effective from 1st April 2021. The bench of Acting Chief Justice M.N. Bhandari and Justice P.D. Audi K. Sivalu followed the previous judgments by Allahabad High Court and Delhi High Court and held that the procedure contemplated under the amendment provisions from sections 147 to 151 of the Act sought to have been followed for the issue of reassessment notices. National Company Law Tribunal Mumbai, in a bench comprising of Mr. Rajesh Sharma as technical member and Mr. H.V. Subbarao as judicial member, dismissed an application filed under Section 7 of the Insolvency and Bankruptcy Code 2016 against Sangola Taluka Sehkari Sakhar Karkhana Limited or corporate debtor on the ground that the same is a cooperative society and hence is not a corporate person to whom IBC applies. The NCLT also noted that while the central government has issued notifications with respect to CIRP against a corporate debtor and also personal guarantor to corporate debtor, no such notification has been issued with respect to a cooperative society. That's all for today. I appreciate you joining us. I am Taniya Pandey for LiveLaw and you're watching Courts This Week. Have a great day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.